Gentlemen, good evening, good afternoon, and thank you for your attention during this trial. When I first started out this trial, we talked about the concept of burden of proof. And at the end of my summation and the summation of the plaintiff's counsel, the judge is going to instruct you about the concept of burden of proof. It is the plaintiff's burden to come forward with evidence to support each and every allegation that she has made against my clients. You're the judge of fact. You get to make a determination whether she has met that burden. Evidence by a preponderance of the evidence on each and every claim. Now, she's made two very serious allegations against my clients. She's claimed that she was wrongfully dismissed because we violated her public policy of not allowing her to speak. This is not a case about freedom of speech. This is not a case about suppression of a person's right to have feelings about programs that they may not agree with. This is a case about a breach of trust. This is a case about an agreement between an employer and his employee about what's expected and what's not expected. We met our bargain. We gave her a good place to work. She never complained about it. You didn't hear a stitch of evidence in this trial for the entire time that she worked for us that there was anything wrong with the environment, that we ever tried to suppress her opinions. She had a problem when she violated the policy that she explained to you she knew. She went into her boss's computer. She saw an email. The email was marked confidential. You don't need an expert to tell you what that means when you're an employee. You don't need an expert to come in here and tell you when your policy says don't disclose confidential information, it means just that. Because when you do that, you hurt your company and you hurt your fellow employees. She is here. This trial is now. The obligation to come forward with evidence is today. And I submit to you, ladies and gentlemen, the scales of justice do not tip in the plaintiff's favor. There's an absence of evidence. In your common sense and good judgment, in your workforce, do you not know when people are messing around in the workplace? Does that make sense to you? Because if it doesn't, you should reject her and her testimony. You heard testimony that some of the rules in our workforce aren't perfectly applied. We're not perfect. We try to give a good place to work. We try to treat people fairly, and we do the best we can. But the idea that Ms. Sabala was fired because she refused sex with Mike Stanhope is her word and no other word, no other support, not one piece of evidence. She neither made a claim with any EEOC. She never told a friend. She never told a family member. She never reported it to anybody at HR. If it was unwelcomed, if it was unwarranted, someone would have to know. And that evidence is absent. She told you that as a result of this incident that she's been harmed. She told you that she is requiring emotional help. She goes to a treatment center. She sees doctors. She came into this courtroom and told you that as a result of this dismissal that she's depressed. Maybe she is. But today is her day. This courtroom is her opportunity to bring to you the proofs that support the allegation. Where are those doctors? Where are those witnesses to support the change in her demeanor? Where are the diagnoses from skilled professionals explaining to you the causal connection between the termination and the depression? They're not here. And the time is now. This is the moment. This is the courtroom to bring your proofs. Because as you decide this case, you don't decide the case on arguments. You don't decide a case on accusation. When you go back to that jury deliberation room and you are deciding who to believe in this case, ask yourself, where are the proofs? And if there are insufficient proofs to meet her burden of proof, you must find for the defendant. Thank you for your time today.
This is my only chance to summarize for you what the evidence has been in this case and to explain why that evidence leads to just one conclusion. That one conclusion is that to reach the fair, the just, the legally supported result in this case is jurors. The only result you can reach is to find in favor of the plaintiff. Now, when you were selected as jurors, you raised your right hand and you took an oath. And you swore to reach a just verdict based on two things: the facts and the law that will be given to you. But there's another thing that you can use to decide this case, ladies and gentlemen, and that's what's down here. That's your common sense. When you walked in this courtroom and you were picked as jurors, you brought that with you, and we didn't ask you to leave that at the door. And I ask you to bring that good old grandmother's common sense to bear in this case. Because when you look at it, when you hold this case up to the light of day, you know what went wrong. You know how this woman was mistreated by this corporation. And you know that this is her only chance to seek some justice. Once you leave here, this corporation is going to go on doing what it does. It does not care about Christine Sabala. It's going to move on doing its business. She is going to remain unemployed, out there searching for a job. She is going to be out there unemployed, worried and scared about how she's going to put food on her table because she lost her livelihood due to the actions of this corporation. Now, this case reminds me of that expression. It's all fun and games until somebody gets hurt. And that's what we have here. We have this little inner core group at SC thinking, wow, won't this be fun to create some funny emails? We'll really have a gas here and have a joke. And it probably was funny when it started. But like a lot of problems that happen at work, things go too far. And when things go too far, then there's a problem and someone gets hurt. And the innocent victim in this was Christine Sabala. And this is the chance now to say to this corporation, you went too far, and an innocent person was hurt. Now, they knew they were jokes. They knew they weren't, nothing confidential was being released onto the internet. They all knew that, but she didn't. And she took this seriously. I'm going to talk about it why in a moment. But everyone was in on it except her. Now, why didn't they let her know at some point so the going too far didn't have to get too far? They could have. They should have. They didn't. And now they are going to pay the consequences through your verdict. The defense doesn't want to talk about this. Boy, have they shied away from this. In this economy, in this day and age, what it means to be fired. They don't care because they all have jobs. They don't care because they're all up on the 24th floor. They don't care because he is still writing joke emails. They don't care. Meanwhile, she's on the therapy couch, unemployed, trying to find a job without any income right now. I'm going to conclude now, ladies and gentlemen, with these points. I have a client whose life was turned upside down. It will never be the same. You can bring back a little bit of her dignity. You can bring back a little bit of economic security, replacing what she has lost. It would mean so much to her if you would find in her favor to help her put some of the pieces of her life back together. Now, there have been a lot of interesting whistleblowers There have been a lot of people who have stepped forward over their careers, most notably the woman at Enron who said, I know what's going on here at Enron, and I'm going to lose my job, but I'm going to step forward and blow the whistle on this corporation and say this is not right. And she came under public ridicule at first, but then was vindicated. Well, Christine stepped up and said our company shouldn't be doing this kind of thing, these kinds of things, and she spoke up at great risk to herself. And she did that because it was the right thing to do. And for that, she's sitting on the unemployment line. I ask you, do not let this corporation get away with their fraternity boy-type pranks. Tell this man, it's not cool that you're still doing this, still writing these emails, still joking, and still risking your employees. And by the way, when you get caught, stand up and take responsibility. Don't fire your employees. What you decide is fair and reasonable compensation is jury work, and that's hard. To get back in there and decide how much money you should give my client, that's up for you to decide. That's jury work. Whatever that number is, we will accept that, and we appreciate that. The most important thing will be that finding that says to this corporation, what you did is wrong, and you cannot get away with it. Thank you very much for your time, ladies and gentlemen.
So really, really great job. Some specifics, I'll start with Ted just because you went first. I thought you did a good job of stating for the jury what the burden of proof was, and without overstating what the plaintiff had to do, but really focusing on the fact that they have to present some evidence, they have to show some evidence, and where's the evidence? I thought that was a strong way to start. I think you did a good job of simplifying the case, saying that this is, basically this is a case about discipline. You have a rogue employee who goes and does something that, pretty much without dispute was wrong, violated company policy, and it's just that simple. Companies have to be able to protect themselves and take appropriate action. I thought that was a good point, and really, again, kind of simplifying it for the jury.
You had a witness, your client. And I thought you did a remarkable job. And this is so hard because you're so gifted, both of you. But at the end of the day, you asked for my fair and frank comments. That's mine. But a great job, both of you, outstanding.
I liked that you started and ended with big themes, and that everything you said backed those themes. And you really, to echo what Chuck said, you really delivered. Your presence, your diction, your inflection, all really exceptional. I couldn't be more impressed. I like that you talked about big ideas like breach of trust, things that people on a jury are going to understand, things that are going to resonate. Really, really effective. Throughout your presentation, you hammered the lack of proof. You were like a rabid dog on that point, and you started with it, it was in the middle of your presentation, you ended with it, and I thought that was extraordinarily effective.
You both did a fantastic job. I mean, it was really superb watching from the beginning of the day and watching you use the various litigation tools all the way to the end. Really fantastic to watch it. Let me do it in reverse order, the way everybody else did. I'm going to start with Dana. I thought you did really well at developing the typical plaintiff's themes that you like to see from a plaintiff. The individual versus the big bad corporation. It was the fun and games until somebody gets hurt. I think you could have connected that up a little bit better to, you're talking fun and games by the power brokers of this corporation. So I thought the theme development was very good. I think you could have done just a little bit better job in working the facts into the themes a little bit more.
The simplicity of it is kind of the complexity. And, this is not a case where we're dealing with, a lot of science, accident reconstruction, or some type of engineering analysis on a product defect, or an improper financial transaction that has a lot of complexity to it. But the dangerous thing about this case, and what I think it makes it very difficult for you all prosecuting and defending it, is it's so relatable. And not to state the obvious, but ours is a service industry, and with the development of technology, a majority of us and a majority of the jurors that you guys would have been facing if this would have been the real deal, are going to have experience in offices and either are going to be victims of sexual harassment, some of them, or at least know somebody who has or has been terminated or accused of it. So they're all going to be coming in here with their preconceived positions, and that is something that you all would have to dance around.